Got to report. You have to report, if nothing else. And you were gone. You were AWOL.
Did you? 2 years.
Because this thing was filed
4 months.
October 2nd, 2023, which is 2.5 years ago. And we never got around to the hearing until, I guess, you walked off the job essentially on September 14th of 2023 and never found your way back that day. What does it show when he was
Just a second.
put into custody?
I can find it.
When was the last time the probation?
Right out of the gate, Judge Stevens is establishing the one rule probation absolutely depends on communication. Courts can sometimes work with missed payments, failed plans, even setbacks, but disappearing completely? That's where judges start seeing defiance instead of struggle. And notice the language here, AWOL. He's framing this like abandonment of duty, not just a misappointment. That tone matters because once a judge believes someone walked away from supervision intentionally, the entire hearing becomes about trust instead of excuses.
Saw it.
Well, since he posted bond, he has been reporting to the probation department.
I'm talking about from the time he stopped reporting until he came back. What period of time is that? Yeah, he found his way back according to authorities, with authorities' help. See, the thing, you have to report, or you're not on probation. That's the essence. You're on supervision, or you're not. And I tell them, if you can't do anything else, you got to report.
He was arrested on December 16th, 2025. And after he
But that
he
was
fled
2 years from 23 when he last failed to report.
After he pled, he was released on February 9th. And then he's reported.
How much time do we have on him?
It's not a lot, Your Honor. Just doing the real fast math here, it's a little over 2 months. Right at 65 to 70 days.
Get it accurate. How much more?
No, I mean, I'm just guesstimating.
Maybe it's plea time also.
Oh,
Your Honor, at the appropriate time,
go ahead.
Mr. Renfro wanted to address for an explanation.
And we're ready on what should be done. Who wants to start?
Defer.
Go ahead.
Yes, so I didn't report. Wow. Actually, what happened, I had COVID. I saw my paperwork against the court. I saw too much scared off my probation officer. And somehow they didn't get it. I guess I saw the email.
For 2 years, so.
Oh, yeah,
Explanation is not.
Oh.
I want to hear it.
But that was
Don't start off with once upon a time.
over the phone verbally that take care of my business with him and keep reporting over the phone to him. I know he had a job, he was still walking there, it's not showing up, but I was reporting over the phone to him.
Were you?
She was not there.
Yeah, I don't believe that either, because that's not the way we worked. And COVID was in 2020. And it passed on reporting soon enough. It wasn't for years. He failed to report September 14th, 2023. It's not COVID. It's not COVID. Come on.
This is one of the worst moments a defendant can have in a revocation hearing. When the judge openly says, "I don't believe that either." At that point, the credibility damage is already happening in real time. Probation systems are built on documentation. In-person check-ins, logs, GPS, test records. Verbal, "I thought it was okay." Explanations usually collapse fast once records don't line up. And you can hear the judge getting impatient because he's not hearing accountability. He's hearing layers of explanation. Big difference in a courtroom.
And you were gone for 2 years. That's not COVID. Over 3 years before you just walked off the job. contacted the officer on February 11th of this year, stating you would not be able to report for your visit due to lack of transportation for February 13th, 2026 at 1:45. You failed to report on February 13th, which prompted the officer to contact you and inquire why you had. You remember that?
Yes, sir.
What did you tell them?
I was seeking up provide paperwork from the LC.
I'm sorry.
I was seeking up provide paperwork to the LC.
No, what did it say? Well, why didn't you report? Where were you that day?
Being tested for flu.
Okay. Where?
Walgreens on College Street.
That's what you're going to stand by? That's your story?
Yes, I signed you.
Well, your GPS device doesn't show that. Strangely enough. GPS, you have one, right?
Yes, sir.
No, it shows you were not present at Walgreens at that day at all. Also, you reported in February, denied any use of alcohol or drugs, then tested positive for alcohol, and then said, well, that was because, I'll tell you now, I did drink alcohol last night. Not until we catch you are you forthcoming.
No,
And you, if you can't be honest with us, if
Yeah.
you can't be honest with us, because we give a lot of trust to the people, but when the trust is found to be broken,
And this is the moment the hearing really turns. Once the GPS evidence comes out, the conversation stops being about misunderstanding and starts becoming about deception. Courts rely heavily on objective verification. GPS monitors, drug tests, timestamps. So when a defendant's story directly conflicts with digital evidence, judges often interpret that as intentional dishonesty. Question for you guys watching. If someone already violated probation badly, does honesty afterward help save them, or is the damage already done by then?
you've lost your credibility. I wouldn't trust you either. I think you've broken the trust.
The court said continuing him on probation.
I
I think he said continuing the probation.
It was the officer is reluctant to recommend continuing his
So
probation.
does that mean she's reluctantly recommending that he
No,
continue to?
he's reluctant.
This isn't the same.
He knows what it is. He's playing semantics.
But it doesn't appear that she's really not sure. I just think there might be something like this.
I know the lady, and I know what she wants. I know what she's trying to convey. We're disappointed.
No, I apologize. I didn't.
You can apologize, but we caught you lying. Anyway,
I don't see anything other than just repeated infractions of the same deal. He wants this on his terms and his terms alone, and that's not how we operate, Judge.
the whole thing is bad enough. He failed to report, and he was absconding for how long?
2 years and
Yeah.
4
I mean,
months.
that's hard to explain away.
Performance while he was on the bond pending the disposition of the case, and whatever his actions were, I guess, speak for themselves through the probation department.
I mean, he was sentenced to 5. Well, the thing is it's once again, it's if you can't do anything else, you got to report. You have to report, if nothing else. And you were gone. You were AWOL. Have you ever been to?
Notice how the judge keeps repeating the same phrase over and over. You have to report. That repetition is intentional. He's simplifying an entire case into one core failure. So there's no confusion about why probation is collapsing. And legally, repeated absconding is one of the fastest ways to lose judicial sympathy because probation is already considered the alternative to prison. From the court's perspective, they already gave the second chance. Now they're deciding whether it was wasted.
In the military? Well, when you're AWOL, it's not good.
He wanted to. Is that what you're going to say?
When I was under, I had an opportunity for the railroad as a job, a track conductor. I was trying to get there.
I don't care. You were supposed to report. You missed reporting for over 26 times? 26, 27 times in a row. Nobody does that. And what's good for one is good for all. If I said, okay, I'm passing Mr. Renfro, then everybody would say, I want the Gregory Renfro Rule. I can trail off for 2 years.
This is where the philosophy of the entire case comes together. The judge is basically saying probation only works if participation is consistent. Not partial, not occasional, consistent. Once that consistency breaks for years, the system stops seeing potential and starts seeing pattern. The real tension here is whether punishment is still correction or just consequence catching up.
For 2 years and come and wander back, and we'll pick up where we left off. I can't do that. If I've always said it, 19 plus years. If you can't do anything, you got to report, or else you're really not on probation. You're on your own probation, which is the tail wagging the dog. It's not working. It doesn't work naturally, right? I mean, I'm willing to drag you across the finish line in some cases just to get you finished, but you got to do the heavy lifting. And 2 years plus is a long time. Any of those days, 800 days, any of those days, you could have walked up and said, before y'all go send something, it's gotten the best of me. I'm here.
That line right there, you're on your own probation, is probably the most important statement in the entire hearing. Judges hate the idea of selective compliance. Showing up only when convenient completely defeats the purpose of supervision. And honestly, you can hear frustration mixed with disappointment here, because the judge is basically admitting he does try to help people finish probation successfully. But after 800 plus days gone, the court now sees a pattern, not a temporary setback.
I want to pick up, please, have mercy. But no, you got arrested, right? Yes, you got arrested. You didn't. We had to find you. And that's not the way it should be.
But
Yeah, go ahead. Go ahead.
One reason because
Yes, sir.
my mom died in January, and in January is when I had to drink, so that was the only reason.
Fine. It's not the drink that's carrying the day. It's the failure to report for 2+ years. That's what life includes death. We all have happiness. We all have agony when we lose loved ones, but we just don't quit. It makes me teary-eyed, but your mother would want, but what you want to be is proud for your mother. But the 5 is the minimum, is what we're dealing with here, because it was 5 years that was suspended and you were placed on 10 years. Yeah, I'm sorry. There you go. Okay, Judge. Thank you. So, once again, I find there is sufficient evidence supporting this motion to grant it by a preponderance of the evidence or greater, as allegation 1 is proven true.
And there's a final result. Probation revoked, 5 years imposed. But listen carefully. The judge keeps emphasizing this wasn't about one bad day, one relapse, or one missed meeting. In his eyes, the deciding factor was prolonged disappearance and repeated dishonesty afterward. That's why revocation hearings can feel so brutal. By the time they happen, the court is often reviewing an entire timeline of behavior, not a single incident. The biggest question here is this: at what point did this case become impossible to recover from?
By a preponderance of the evidence or greater, and your probation is hereby revoked. You are sentenced to 5 years in prison, and you will be given credit for all time you have served in accordance with this case. And good luck to you, sir. I have Stephen Allen.
But that was my last year.
And this is where everything comes full circle. The court isn't reacting to one mistake. It's reacting to a long pattern of missed obligations and broken trust. Once probation stops functioning as a supervised agreement and turns into repeated absence, the outcome becomes almost inevitable. 5 years doesn't come from a single moment. It comes from everything leading up to it. So the real question is, where should accountability have kicked in before it reached this point?